I want to say welcome again. For people who don't know me, my name is Nat Paul, and I am OJEN's Director of Educator Support. This is the second in our summer series of webinars that are replacing what was normally be our Summer Law Institute. And they've been going really, really well. I should take time off the top to point out that we do have 4 more in the series coming up. August 5th, we have one on the environmental challenge being brought against the Ontario government by a group of students. August 13th, we're talking about COVID and its impact on various areas of law. August 18th, we have a neat session on fertility law. And on the 27th, there's going to be OJEN staff discussing the ways in which our organization is modifying our practices and what we have in store for teachers to help you as you see what the school year is going to unfold like. So like many of you, we are waiting for August 4th with bated breath so that we have some sense of how it is that we're all going to be learning and working together going forward. I am the least important voice here today. I have some colleagues helping me behind the scenes. Christy Pagnuti is our program manager and is the main organizer for all things institutional and this series in particular. Michelle Thompson also is here. She's our manager of legal and digital development. She's managing questions and running things on the back end, which is super because it really shouldn't be me. And finally, I need to acknowledge our fantastic high school intern who comes to us through the laws program, which many of you may be involved with at your schools. She's Kelly Chung from Harvard Collegiate, and she has been fantastic. We're sorry to see her week with us ending this year, or her time with us ending this week. Michelle's already said this, but I'll reiterate, please keep microphones off and cameras off. This helps us with bandwidth. When there are questions, and there will for sure be questions, you can type them into the Q&A or you can put them into the chat. We are monitoring them, and depending on whether they're super pertinent to what's actually being talked about at the moment, we may pass them on to Justice Sossin. There will be time, 15 minutes or so, for Q&A at the end as well. I would note as well that the presentation is being recorded and we will be posting it on OJEN's website soon. We should be able to get the video link to you folks in a matter of a couple of days. So I'm super happy to be doing this. One of the things that we traditionally do at this point is a kind of a land acknowledgement. This becomes interesting given the logistics of virtual meeting. In addition to this, there is a sort of interest underfoot to really rethinking what land acknowledgements are supposed to do. We've been very much impacted by the perspective of a wonderful lawyer and educator activist who's been working with us, that's Leah Horzempa, who has given us a lot of really good ideas about what we can do to make a land acknowledgement an ongoing active thing. So while I will say, as we normally do, that at least I'm in Toronto and many of us are, which is the traditional territory of Mississauga of the New Credit First Nation, as well as Anishinaabe, Haudenosaunee, Wendat, and Huron Indigenous peoples. It's not just history. These are folks who have an ongoing presence in our communities, so we do not relegate them to being an article of the past. And we, in order to keep this from being just a box that we tick, we're encouraging everybody to think about an acknowledgement as part of an ongoing embrace of a reconciliation effort. Thinking about something which is particular to the day and the kind of meeting that we're having. And so because we're talking about legal cases and precedent and things like that, it makes me think about how often we approach treaties as things that happened in the past. You know, the ancient history from a long time ago. And it seems to me like this is a good time to point out that when we say things like we're all treaty people, these are actually ongoing live legal arrangements that are in place right now. And not all of the country is ceded territory. So it might be of interest to some folks to know that there is actually a super innovative new treaty under negotiation right now, which covers Western Quebec and Eastern Canada. So that's the Algonquin Treaty negotiation. And if it's of interest, I can put a link up in the chat so that you can see that and see what's going on with it. This will be covering 1.2 million people, so not small at all. Much of BC is unceded, the Maritimes are unceded, and it's really interesting to look at treaties by thinking about what's not covered by treaties some of the time. With that said, I'm going to introduce our speaker. This is one of our most popular series. And so it's a great pleasure to me to be able to welcome Justice Lorne Sossin. who will be familiar to many of you as a frequent contributor to the ongoing legal discourse in Canada and elsewhere. Justice Sossin was appointed to the Superior Court of Justice in December of 2018. Prior to this, he was professor and dean of Osgoode Hall Law School at York University. Before that, Justice Sossin was professor with the Faculty of Law at U of T. He is a former associate dean at U of T and served as the inaugural director of the U of T Center for the Legal Profession. Justice Sossin's teaching and research have spanned administrative and constitutional law, civil litigation, legal ethics, and the judicial process. Speaking of judicial process, Justice Sossin clerked for the former Chief Justice Antonia Lamer at the Supreme Court of Canada, has been an associate in law with Columbia Law School, and a former litigation lawyer with the firm of Borden & Elliott, which is now BLG, Borden Ledner Base. Has doctorates from U of T in political science and from Columbia University in law. Justice Sossin has published proliferately, including books, journal articles, reviews, administrative law and practice, principles and advocacy in 2018, administrative law and context in 2018, middle income access to justice, and the list goes on and on. There are 6 or 7 more of these. In addition to which, Justice Sossin has served as the research director for the Law Society of Upper Canada's Task Force into the Independence of the Bar, commissioned papers for the Gomery Inquiry, Ipperwash Inquiry, and the Gouge Inquiry, and served as vice chair for the Ontario Health Professions Appeal and Review Board and Health Services and Appeal and Review Board. In addition to that, he is a legal firecracker with lots to say about lots of what's going on. So I'm going to get out of the way and turn it over to you, Justice Sossin. I'll be off camera and I leave them in your very able hands. Thank you very much.
Thank you, Nat, for the very generous introduction and the acknowledgements and helping to get us started, and to Christy, Michelle, Kelly, all those who have made this very distinct Summer Law Institute for 2020 happen. It is terrific to be a part of this. Welcome to those who are tuning in, and welcome back to those who were also there in August last summer when I did my first run through on the 5 most significant cases coming out of the Supreme Court. And I'm delighted to be back with another 5 really interesting, provocative cases, many of which I hope find their way into your discussions as educators and your classes. And I'm looking forward to your questions. The Q&A QA function should be at the bottom of your Zoom screen. Please use it as I go along if there's clarifications that would be helpful, and otherwise use it for broader questions. And as Nat said, there'll be time for those at the end. I'm going to start a slide deck now, so it's just going to take a moment to share my screen, and we'll see if the Zoom gods are kind today. So just bear with me as we start the slideshow. All right, so again, if there are technical glitches, my OJEN colleagues will pop in to advise, but otherwise I'm assuming you can see the first screen, which is the cover. And even though we're looking at the 5 most significant cases of the year, of course, there are many more than 5 that one could talk about. Some we're just getting headlines this week. The ruling on the safe country rule for immigration and refugee purposes, and the charter was just decided by the federal court. It's generating a lot of controversy. The safe third country rule being struck down. A number of other cases that are attracting attention across the country, and some of those, no doubt, will make it to the Supreme Court in due course and be a subject of discussion. But I tried, as I did last year, to really look at what are the cases we're still going to be talking about 5 years from now, 10 years from now, that came out of the Supreme Court between last August and today. Excuse me. So the five that I've chosen and that I'll discuss briefly in this this talk are first Canada and Vavilov, which is actually the only 2019 decision. It was a holiday present by the Supreme Court of Canada in late December 2019, and really has reshaped the field of administrative law in ways that are continuing to influence courts and tribunals across the country. And again, I'll give you a flavor, at least, of why the case has been so significant. And for each of these, I'll give you a snapshot of the case, but really focus on the takeaways. What is the reason these cases have significance? And I'll be drawing, I should add, to a considerable extent on the case in brief service of the Supreme Court that tries to distill cases in very accessible language, and again, I think is a terrific teaching tool for those who haven't tried it out. I have hyperlinks to each case to that Supreme Court service. The slide deck will be made available after today's talk, and I hope it serves as one of many resources that assist you in planning for, again, how to tackle these current developments in your own work. Second case will be a reference into the Genetic Non-Discrimination Act, and it's the first, again, of a series of 2020 decisions. Araya and Nevsun resources dealing with the role of international law and allegations of serious human rights abuses against a Canadian mining company that engages with those international law concepts. Uber and Heller, a case, as you would expect from the reference to Uber, that very much engages with the gig economy, and particularly how the tech companies frame their relationship with those who carry out the work as employees, as contractors, and what happens when there's a dispute between those individuals and these large companies. So more on that in a minute. And finally, the Ahmad case dealing with entrapment in criminal law, but it happened to come out just a week after the protests had begun in the US in June on systemic racism and a range of issues that have roiled not only the US, but the globe in terms of focusing on systemic racism in the justice system. And that was an aspect raised by the majority of the court in that case. And again, I'll touch on that, in addition to some other notable developments at the Supreme Court of Canada. In fact, indeed, on the response to those protests, in addition to some other issues. So stay tuned, that's what's to come. So let me begin with Vavilov, which, as some of you may know, is the case involving the real-life version of what became the Hollywood series, The Americans. This is the illegals program that the Russians embarked on over a series of decades, in which people were placed into different identities to lead ordinary lives, but covertly to carry on espionage for the Russians. So those of you who haven't seen the series, it's compelling watching, but doesn't involve Canada to any great extent. And yet Alexander Vavilov, or Alex Foley as he was born, is the, again, real life version of this. An individual who grew up in Canada, later lived in other countries, and only in 2010, so when he was already a teenager, did he discover that his parents were part of this program. Fast forward a couple of years later, he applies for a renewal of his Canadian passport. Having been born in Canada, of course, he always had one. And after a series of back and forth, the government decided to reject his application for a passport because it rejected his entitlement under a provision of the Citizenship Act that excludes the children of diplomats from foreign countries from eligibility for Canadian citizenship. So anyway, that's the backdrop, but the case really was a vehicle for the Supreme Court to explore the judicial review framework. That is to say, when the government makes decisions, could be a minister or delegate or tribunal or agency, when any part of that executive branch makes a decision, the question is on what grounds and with what kind of scrutiny can it be challenged in a court. And this field is called the standard of review. And it really captures the idea that the court will not simply put itself into the shoes of that decision maker, in this case, a registrar making a determination on citizenship and say, what would I do? But rather looks at what the decision maker did and asks the question in the overwhelming majority of cases, apart from some exceptions that we don't have time to explore, asks the question, was it reasonable? And there's a framework for how to determine reasonableness that the Vavilov case and two others dealing with, of all things, the CRTC's decisions about Super Bowl ads coming from the US and how they're broadcast in Canada. These together formed a trilogy on the standard of review. And in addition to a finding that deference or this reasonableness review would be the appropriate way for the courts to look at these decisions, the court went on to say what that review focuses on. And it focuses really on justification. Did the decision maker demonstrate, usually through reasons, that she or he wrestled with the appropriate issues, discussed and justified the decision that they reached, and did so in a way that didn't misconstrue what the legal requirements were in this case. So that's the reason Vavilov is significant in one respect. But if I were to give you the spoiler alert for those who haven't read it yet, the conclusion of the court with respect to Mr. Vavilov is that the registrar denied him a passport unreasonably. In other words, treated his situation as akin to a situation of the child of a foreign diplomat, which is manifestly not the case. These weren't diplomats, they were covert spies. They weren't, in other words, part of that community for which that aspect of the Citizenship Act was created, where there is a set of privileges and responsibilities of foreign diplomats. So Mr. Vavilov gets his passport, but more importantly, we get a whole new framework of how government has to justify decisions if they're going to survive judicial review. And I've got a picture of our nemesis COVID-19 there for a reason, and that is that this framework, among other applications, has been coming up in the lower courts quite frequently around challenges to COVID-19 orders and restrictions. The change, for example, in hospital policies to limit visitors, or chief medical officer of health directives, and a host of other settings that by next year, no doubt will feature in this review with appellate decisions coming as well. But I want to make that link again to show the relevance of a case that can seem quite abstract on the standard of review, but is quite concrete when one then looks at how challenges to decision-making will unfold in the courts. So for that reason, before I leave Vavilov, let me again just say, for any issues to do with administrative law, which covers everything from procedural fairness to the nature of reasonableness, Vavilov is going to be a point of departure for the years to come. So moving to the second case, which again attracted a fair bit of media attention, reference into the Genetic Non-Discrimination Act, which again was a piece of legislation that had a very unusual trajectory on which the government asked the courts, different provincial governments first, notably in Quebec, asked the courts to determine whether this law was constitutional. This made it up to the Supreme Court of Canada. That's the decision that I'm looking at. And the argument really turns on whether this law, which let me just jump to it, at least its core provision right now, law that makes it a prohibition for anyone to require a genetic test as a condition of providing goods or services, entering into contracts, and particularly insurance, where this had been developing as a requirement, for example, for life insurance, that you first undergo a genetic test. By making this prohibited, the protection was said to encourage more people to seek out testing without fear that it was going to lead then to services being denied, or that it would be used in third-party contexts over which the person whose genetic profile was being tested would have no control. So a privacy concern as well. All right, well, the issue came down to this. Was this legislation a valid exercise of Canada's criminal law power under the old Constitution Act of 1867, or the BNA Act for people of a certain generation like me, which again can cover a range of protection and promotion of health, among other concerns for privacy, etc. Or is this really legislation aimed at how we engage in contracts for insurance, for goods and services, which falls squarely into provincial authority under the division of powers in the Constitution Act of 1867. So the Quebec Court of Appeal had said this is clearly about contracts. You see contracts in the terms, struck it down. But by a narrow 5-4 majority, the Supreme Court of Canada upheld it and upheld it as a valid exercise of that criminal law power because it combated genetic discrimination and protected health. A concurring decision by 2 other judges that saw it less as directed at discrimination, more at control over one's own genetic information, but the same result. So those are the 5 who ruled in favor of upholding it. And a notable dissent written by Justice Nicholas Kasirer took the opposite view, the Quebec Court of Appeal view that this is really about contract law and therefore can't be a valid exercise of the federal government's constitutional authority. I say notable because it's the first major decision written by Justice Kasirer, who is, as many of you will know, he is in his first year of his appointment to the Supreme Court. So lots of eyes on him for his style, his commitments. And so this case in which he was joined by the Chief Justice among 2 other judges, notable, close decision. I said it had a distinct trajectory. The case actually came about because of a private member's bill. Liberals, both in the Senate and the House of Commons, passed it, but without the government's approval. And in fact, the cabinet voted against it. So the Attorney General was Judy Wilson-Raybould at the time, took the position, joining with the Attorney General of Quebec and other provinces, that this was unconstitutional. So in the Supreme Court, you have the government arguing that its own law was beyond its constitutional authority. The Supreme Court somewhat awkwardly had to appoint an amicus to make the argument for why it would be constitutional, in addition to some interveners who took that role. And of course, that was the winning position. So very odd to see the Attorney General for Canada opposing Canada in justifying and defending its own law on constitutional grounds. Certainly, I can't think of another case in which that's happened. So what are the takeaways? Well, again, we have this expansion of where the federal government can legislate around genetic discrimination, autonomy, privacy, equity, public health, that could have broader ramifications for the future. And as Marcella Day said in a media account when the case was coming out, that to take a genetic test that could save your life should not come at the price of you not being hired or promoted, able to adopt a child or to travel, not being able to get insurance or access childcare. And that really, I think, is the rationale for the majority in its upholding of this legislation. So moving to the third case, and mindful of time, let me say that much of this case is a great one-stop shopping case for all of international customary law. This is international law can often be broken down into laws arising from treaties, conventions, and agreements, multilateral and transnational. But there's also this body of customary law that is said to again exist even without Canada signing on to any treaty about it, that protects some core human rights and related protections for all people against again typically the acts of states. In this case, there was a lawsuit against a Canadian mining company that owned a mine in Eritrea that was alleged to have engaged in compelling people to work in very dangerous conditions. So torts of unlawful confinement, negligence, and forced labor, slavery, cruelty, crimes against humanity, degradation. So a very disturbing case in terms of the alleged facts. And the defense was really a doctrine that exists in the UK, but had never really been confirmed in Canada, called the active state doctrine, where the courts of one state can't find the actions of another state to have been illegal on these kinds of grounds. And the Supreme Court of Canada says, well, that just doesn't exist in Canada. That's not a bar to moving forward with a suit. I should add that this lawsuit was only at the stage of written pleadings. So no evidence had been tested. There hadn't been a trial. Nothing had happened beyond that exchange of claims and defenses. So we don't know yet what will be shown. But the court nonetheless said that it's not plain and obvious that this couldn't succeed if there's evidence there to substantiate it. And that's the test when it's at such an early stage. Could it possibly succeed, or is it plain and obvious that it couldn't? So court said it's not plain and obvious that it couldn't succeed, and more importantly, that customary international law is part of Canada's common law, and it becomes part of Canada's common law automatically, as opposed to those treaties and conventions, which only become part of our legal system when ratified by the legislature and brought in. So in this case, the court didn't say that Nevsun was responsible for violating any of these workers' rights in the ways alleged, but that it ought to have its day in court to make that case. And it can use customary international law that has what are called peremptory norms, again, about the preservation of human rights, and which would be violated by, of course, any examples of slavery, forced labor, the other things alleged. So that will be the basis now of a major case moving forward. And here's a picture of the mine. It doesn't come across quite as clearly as I would have liked. And it's the Bisha mine is the subsidiary owned by Nevsun. So it also has a Canadian multinational resource extraction dynamic to this case as well. And of course, the Eritrean workers are bringing this case because they were accepted as refugees and now able to bring this case in Canada. So I mentioned the takeaways on the case itself, but there is a broader theme that Justice Abella, who writes for the majority, talks about in very, again, dramatic language of the phoenix that rose from the ashes of World War II and declared global war on human rights abuses. And there's a particularly compelling story, of course, for Justice Abella, who herself rose from the ashes of World War II. She was born in a displaced persons camp in the aftermath of World War II and the Holocaust, before her family made their way to Canada. And so she's writing about a journey, a legal journey, that in some ways has a direct implications and parallels for her very compelling life story. All right, so let me deal with these last two cases in the 10 minutes or so that I have left. One, again, involves one of the biggest icons of the gig economy, Uber, and a class action against that company seeking a range of damages in I think the neighborhood of 400 million for treating its drivers as independent contractors rather than as workers who would have the protections of the Employment Standards Act. Now, when Uber received this legal complaint from Heller, the representative plaintiff of this class, Uber pointed to a provision that every one of these drivers signs in which they agree that disputes will be resolved through mediation and arbitration in the Netherlands, where the company is resident, which of course is at the expense of the party seeking the service. So an Uber driver, in order to have any dispute resolved, would have to pay $14,500 US in legal fees in order just to initiate that process. And in this case, that would represent the representative plaintiff's entire annual income from Uber. So Uber was taking the position that all these drivers didn't have to join, but they did, and they signed this contract, and they should be held to its terms. Heller took the view, and the class took the view, that this was unconscionable, this clause, and therefore it can't be enforceable, that somehow just to resolve a dispute, they would have to spend an amount equivalent to their annual salary. And the majority of the Supreme Court, again, a somewhat narrow decision, but agrees with Heller that the clause can't be enforced and was invalid because of this doctrine of unconscionability. And the fact that the fees were so out of proportion to the kind of income and salaries of Uber drivers really meant that it was a bar to holding Uber accountable in the ways that dispute resolution has to permit. And in particular, the court was mindful of the extreme inequality of the bargaining powers of these two, Uber on the one hand and driver on the other, and that this arrangement was not one that anyone would ever enter into if they didn't have to. In other words, like many of these agreements that are signed as a condition for getting a necessary service, it may have fine print that may say things about arbitration privately done, and this is a common feature of many of these companies. But the court's saying, you know, that's not a realistic view of two parties entering into a contract and agreeing to its terms. It's one party imposing a contract on the other where there really isn't that ability to make a choice. And again, there's both a concurring judge, a dissenting judge, but the majority's decision has implications for not just Uber, but the whole gig economy. I won't be able to give you all of them in this short review, but let me touch on a few. One is that these provisions are proliferating in a number of these settings, again with independent contractors, and the arrangements are not to be able to go to court, but instead having to go to arbitration, and contracting out of, in that sense, the Employment Standards Act. Those are all now going to be suspect depending on how this case unfolds. At the moment, we, again, don't have a case that's been heard at trial or evidence that's been filed. This was Uber's attempt to stop it before it started and compel Heller and the others in this class to go to Holland and have it resolved by arbitration there. So the Supreme Court said, no, this will be resolved by Canadian courts. And if they're eventually found to be employees instead of contractors, of course, that will have dramatic implications for Uber and for a number of other companies like it. And also it may become, given the tea leaves in this case, less popular for these companies to rely on these alternative dispute resolution mechanisms where there is, again, no realistic choice being offered those who need to sign on. Or if you think of all the times you hit accept online when you're looking to engage with a service provider, how many of us really do read over all the terms that we're hitting accept to and meaningfully engage with them and agree to their implications. So we don't know quite which of those might be upheld, which might not, but Uber puts up a red flag on this whole aspect of the gig economic sector. All right, turning to the last case. And again, these are in no order. All of them are significant. And as I mentioned earlier, you'll see each slide that introduces a case has the case in blue. These are hyperlinks to the case in brief. And when I cut and paste from the case in brief to give you the judges who were in favor or not, you'll see each of their names is hyperlinked. If you want to learn more about the judge or want to include some of the judge's story, that's again another resource provided. So this last case, as I indicated in the intro, comes out of a criminal justice setting. It's a case about entrapment. When can the police create the conditions for the commission of a crime and then arrest someone for engaging in it? This was the crime of selling narcotics, in particular cocaine. And the mechanism for doing it was referred to as a dial-a-dope, where a number would be circulating in the community of buyers. You call the number, indicate through some coded references what kind of drug and quantity of drug you're looking for. Then a meet is set up and the actual exchange happens. So the police were getting tips about these numbers and about the names being used, often not people's real names, but enough of a tip that the police officers would then call the number, put in a fictitious order for drugs, set up a meet, go to the meet and arrest someone. And that's how Mr. Ahmad and Mr. Williams, a companion case within this litigation, came to find themselves arrested. And the majority of the Supreme Court took the view that there was no entrapment in one case, and the test being used and similarly applied the same standard in the other, using a well-settled test that requires the police to have a reasonable suspicion before they set the trap, as it were, for the commission of a crime. That is to say, if you only have a tip unconnected to anyone's identity, unconnected to anything else about them, and go ahead and arrest them on the basis of simply calling and setting up a drug purchase, well, then that may be entrapment because there was no reasonable basis to suspect this person was engaged in a criminal act. On the other hand, if you have information about them, you have either about their identity or a pattern of their using this particular phone number for this particular purpose, that kind of thing, then that won't be entrapment. And you'll see some reference to reasonable suspicion on this slide. Again, this was a divided decision, and the entrapment law on the view of the dissenting judges is too broad. But again, on the majority view, the existing approach to this is appropriate. And in terms of a takeaway, I'm citing from one particular paragraph because, as I mentioned earlier, this came on the heels of the protests into systemic racism in the US, in Canada, and elsewhere, This decision came out in June, just a week into those protests. And you'll see the reference to entrapment having a disproportionate impact on poor and racialized communities and serving as a breeding ground for racial profiling, among other concerns. So for this reason, the majority takes a particularly strong view that entrapment is to be discouraged, and there needs to be, again, vigilance by the court to ensure there isn't that discriminatory impact of the use of tools like the one employed in this case. So has significance beyond just the decision. All right, so moving to my final thoughts and conclusion, I said I would say a word about other notable developments. One, which I'm going out of order to the second development listed here, but it flows from the Ahmad case, is the Chief Justice holding a very highly viewed press conference, and a very historic press conference, I think, in which he answered questions about systemic racism in the justice system, the role of the courts in combating or perpetuating some of these concerns, and in which he again declined to engage with some lines of questioning on his own views of the issue, and he preferred instead to point to cases like Ahmad, like Lee, a decision that I discussed in last year's review, dealing with when the police can be said to have improperly detained someone, that again dealt with the systemic racism in the justice system. So the Chief Justice referred to a number of decisions, but did not want to have a freestanding statement or declaration on the topic, which has occurred in some US state courts, but again has not been part of the Canadian landscape. And the press conference, and I have a link to it, the Chief Justice Wagner discusses some of his views on this topic, including the diversity of the bench as a important step forward in addressing the lack of public confidence that may arise after the protests we've seen this summer. So there's a number of things of interest, I think, in that press conference. We also witnessed in June the first Supreme Court of Canada Zoom hearing, and I have a picture of it here where you can see the judges participating along with counsel. Interesting to look at the virtual backdrop chosen for all of them. They're wearing robes, again, a little bit distinct from some other Zoom settings in the era of COVID-19 justice, but certainly a landmark day for the Supreme Court of Canada. And apart from a glitch or two, seemed to unfold successfully. But it's only a matter of time before we move from this image to that image. So Zoom glitches will happen. And if you've been watching any of the live stream judicial hearings and decision making, and we've had a number of landmarks in that domain, the COVID-19 justice era is going to produce some memorable images beyond just ones like this. So coming back to the last item, I mentioned this is the first year on the court for Justice Kasirer, a former dean at the law faculty of McGill and Quebec Court of Appeal judge. He will be one to watch, a very well-respected jurist and academic who's just making his mark in these early cases for the first time. But like bookends, it will also be the last year for Justice Abella, who we were discussing a little bit earlier. And she will meet the mandatory retirement at age 75 deadline in summer of next year. So again, you know, in the over 15 years of her time on the Supreme Court of Canada, she's made remarkable contributions in many areas. Lots more to be said about those, no doubt, as she enters her final months. but a notable development, and of course another appointment process for the court and the government will come in the months leading up to that. So let me stop there with, again, my thanks to you for your patience, and again, apologies for not spending more time on each of these rich cases, but hopefully that gives you a taste and a flavor for why I at least find them to be the most significant. And of course, the usual caveat, I speak for myself, not for the Superior Court or colleagues, and I'm of course open to lots of constructive input on why some cases shouldn't have been overlooked that didn't make the list, and why some of these may not be as significant in your view as I found them. But with those comments, let me pause and see if there's some questions I can tackle from you.
Absolutely. So, excuse me. First of all, thank you so much for that entire talk. Attendees, if you have any questions for Justice Sossin, please feel free to type them into the Q&A function, which you can find at the bottom of your screen. I'll be sort of filtering them and putting them to our valued speaker. So we have one question to start out with. This is a fair bit technical, so don't worry too much if you don't have this at your fingertips. But this is a question from Matthew Wilkes, who asked about the reference regenetic testing. And he notes that in considering the classification question, Justice Kasirer finds no degree of seriousness of harm is necessary to prove a criminal purpose. Justice Kasirer takes the view that the threat must be real in showing a reasoned apprehension of harm. And Matthew asked, with Moldaver and Cote specifically declining to weigh in, what do you think is the test for the classification stage going forward? I suspect that perhaps Matthew has a legal background in addition to—
No, it's a great, it's a great question, and it actually speaks to a broader concern when we're talking about the division of powers and this idea of whether something's going to fall into a federal or a provincial basket of authority. And the question often is, well, can you just say something is about a harm, or does it actually have to have some empirical basis, some study or facts on the ground that are being invoked? And the answer generally is no. That we take Parliament's word at face value. So where Parliament declares that there is a concern or a risk or a need, a mischief is a term often used to address, we don't pierce the veil as courts typically and look behind it unless we think it's a colorable attempt to mask something. So if you, in other words, you can't simply call everything an act to protect the privacy, autonomy, and health rights of Canadians and then have the entirety of the act deal with insurance contracts. So there are limits to these things. But it's actually interesting that there was a bit of hesitancy from the dissent on even the naming of this particular act around genetic discrimination. That, in other words, Justice Kasirer for the dissenting judges said, well, we can't simply look away once the title is given to us as about discrimination. We need to look at it and say, well, that may be the title, but what does it do? And of course, the dissent said this really regulates insurance contracts and other goods and services that are all provincially regulated. So I think, the debate is a real one. And of course, I think the easy cop-out that too many judges take, and I'll certainly embrace at all opportunities, that you've got to take different cases on their terms, and it is a case-by-case determination. It makes it hard to predict in the future, but I certainly think the majority's view and the view in other cases that we take Parliament's description of the mischief or harm that it's seeking to address at face value without requiring that there be what we might call good reasons And this is actually a neat distinction from Vavilov, where a minister makes a decision, not the legislature, but the executive or a bureaucrat or public official or agency, board, commission. Well, then we take a different view and we look past it to say, well, what was the reasoning? What was the basis for it? Is that coherent? Is it justifiable in light of all the environment of laws and facts around it? We don't do that with legislation in the same way, at least not until, if it were a charter case, we might do that in justifying a charter breach in Section 1 of the Charter. But in the division of powers questions, it really does not arise as a look into the minds and hearts of parliamentarians, so much as looking at the words on the page in the act that we're left with. And so that's, I think, what the majority took to heart in this case.
Thank you. I have another question that's come in that actually addresses a case that you spoke about last year, but its impacts today, which is, how is the Jordon decision in the time of COVID impacting what you see in the justice system?
No, that's a super interesting area as well, and of course has come up a lot in the various government and court discussions around the backlog of cases and how significant the challenges are going to be coming back to a more regular or normalized approach to working through these trials. We're going to have this at least 4 to 6 month period where there has been very little activity, and we don't. We actually do have a case from this year that could have been one of the 5, but wasn't. That was a doubling down, a reaffirmation of Jordon. So we know it's alive and well, and the court again is leery of loopholes and it applies here but not there, or here in this way but not there in that. The court's sending message after message that that's not the analysis it's keen to entertain, and those overarching concerns about fairness and ensuring a smoothly functioning justice system and avoiding unreasonable delay where liberty and criminal sanctions are at stake. All of that is going to collide with these very real public health and emergency declarations that made it completely impossible to move forward with timelines. So on the civil side, what the Attorney General actually did, it's a unique power that the government has, it stopped time. So it said the limitation periods will no longer apply after March 15th until such time as they declare them the clock ticking again. So that, in Ontario at least, meant on the civil side that the normal timelines that you might be running up against that limit when you can bring a lawsuit were all going to be stayed. On the criminal side, it's a more complicated process, but I think it's fair to say there will be some balance struck between legitimate delays related to the emergency declaration and the realities on the ground, and delays that may have coincided with this period of time, but may not be able to be justified in the same way. So that sorting out will happen, no doubt, in the months to come, but I would expect we'll see that kind of wrestling with the competing realities. It doesn't, in other words, whether it's for COVID or any other reason, doesn't change the harms that delay can do. But obviously the government and lawyers involved in these cases weren't in control of all the necessary parts to move cases forward that they normally would be, and that has to be taken into consideration as well.
Sure. So another question here about Uber. Do you think that if the arbitration fees were not so enormous and the place chosen for arbitration was more accessible, there would be an impact on the outcome in this case?
So, I think it's an interesting question, and again, I think we need to see some additional cases that attempt to apply Uber first. I think we will see those in the coming weeks and months, but I think the the future courts that look at this are either going to take Uber and Heller to be about more than this one clause in the contracts that Uber drivers sign, are going to take it to be, again, a red flag to a whole variety of things that are part of this construction of relationships as independent contractors, or framing of the Employment Standards Act as not applicable. And the breadth or narrowness of that interpretation is hard to predict, but certainly the language used by the Supreme Court looks indicative of, by the majority, indicative of a court that's not looking to provide narrow guidance just to the class of which Heller was the representative in this case. And the language in particular about unequal bargaining power, improvident contracts that are, again, unfairly imposed, is broad language that certainly could give rise to broad application.
Makes sense. So we have one more question at this time. So everyone, if you want to ask anything, get it in now. This question starts, thank you for the insightful discussion. Could you say anything about the ANCA decision in Sullivan and the defense of voluntary intoxication in cases of automatism? Of course, this was a decision that got a lot of media attention this year, with a lot of different people having different understandings of what the decision actually was.
No, I'm happy to, and let me first clarify, because I think I was in discussing Ahmad talking about the outcome in that case, and I want to clarify that the outcome was that there wasn't reasonable suspicion in either of the cases giving rise to the Supreme Court appeal. So in that sense, these convictions are both set aside on grounds of entrapment, and again, the Court of Appeal differed on the two, and I just want to make sure I'm not leaving an incorrect view of the case, and certainly the case in brief does a great job of laying that out. Turning though to the case that attracted a great deal of attention, again, particularly because when we look at extreme intoxication and the crimes committed in that state, it again can have narrow or broad implications. And the public interest groups, some of whom were involved in the case, others were close observers of how these cases unfold, particularly in sexual assault contexts, saw real alarm bells over the upholding of this kind of defense. Those who were involved, particularly in the criminal defense community, and looking at this kind of within those confines, saw it very narrowly as cases only at the most extreme end, where there is this difficulty in dealing with the fact that all crimes need to have an act and a mental element, and how to ascertain that in context of extreme intoxication. So I think it is very much a product of, did you take a narrow or broad view? But, you know, again, in a somewhat constrained and diplomatic twist that won't surprise anyone as a judge, I tended not to come down on one side or the other as to whether I'm reading it narrowly or broadly, but rather took real opportunity from the debate that ensued in social media, in mainstream media, in classrooms, about what the sexual assault criminal justice dynamics experience are, from the applicable law to, again, much of that lived experience of survivors and others, and an opportunity to really reflect on what kind of legal system we want and what the implications of it are. And again, the balancing of those criminal defense rights with overarching and important goals around wanting to ensure we're not disincenting or deterring survivors from coming forward, and not re-traumatizing in the course of criminal adjudication. All these issues, I think, were brought about or brought up in new ways because of the case. So for me, it was an important discussion, although I'll leave for the experts whether that narrow or broad implication of the decision itself should guide our thinking. And certainly from a classroom point of view, very important issues to engage with. I said this last year as well. Some of these cases, that one for sure, the Nevsun case as well, very disturbing factual allegations, and so very careful work, I think, in how to take it into an educational setting and present it in a way that is going to be appropriate and engaging. But again, these are very, very difficult topics to simply throw out there. And I hope all those tuning in who are looking at their curriculum are giving thought to using their expertise to bring these important issues to a classroom setting where they can inform important discussions. And I wish them well, have a huge admiration for the work they do, and look forward to continuing to engage with them through OJEN.
Your Honor, thank you very much. I'm putting my money on the first case to make it into a classroom being the Uber case. That's the one that I'm carrying through. We're a little over time, so I'm going to just thank everybody for participating and for sticking around. Please, if there are other questions that occur to you, feel free to get in touch with myself or Michelle or Christy. You can find us on the OJEN website. We're happy to follow up with you on these things. Just take a second now to thank Justice Sossin for his time and his insight. These were super interesting. I have questions, but they're nobody else's business other than mine, so we'll save that stuff for later. So there we are. Thank you very much. And for the audience, keep your eye on OJEN's Twitter and things to see what's next and when it's coming out. Thank you very much, and we'll see you all soon.